Hi, thanks for watching. Okay, so today, Judge Stephen Boyce in Idaho denied attorney John Pryor's motion to withdraw as counsel for Chad Daybell. So, as we know, Chad Daybell has been charged with 3 counts of first-degree murder. Okay, and death penalty is on the table. Okay, the state is seeking the death penalty against Chad Daybell. And I would like to explain why I think that if he already had a very low chance of actually receiving the death penalty, I think now with Judge Boyce's denial of John Pryor's motion to withdraw, I think honestly, I think his chances of actually receiving the death penalty have gone down to practically zero. Okay, and I'll try to explain this. Okay, now in the first place, I think we have to be realistic. Okay, no matter how much we're in favor of the death penalty, no matter how much we might like to see Chad Daybell executed for whatever we think he did, okay, the reality is that like California and like some other states, Idaho has a death penalty on paper. Okay, on paper they have a death penalty, but effectively, practically speaking, it's not really a death penalty state. You can't really compare Idaho to Oklahoma or Texas or Florida. Okay, those are the major death penalty states. And even a state like South Carolina that says that it's hardcore on the death penalty, they hardly ever execute anybody. But a state like Idaho or California, I'm sorry, in California, I think like in the last 15 or 20 years, they haven't executed anybody. Okay. And also, like in a state like California, we can see, like in the Scott Peterson case, if anything goes a little bit weird in the trial, there are lots of ways to get post-conviction relief. But the most important thing to remember here is that Idaho is not really an authentic death penalty state. I think that's the most important thing. And so I don't think the system is really designed for the death penalty. And I don't think the judges are really savvy about the death penalty. So even if Chad Daybell were to be handed down a death sentence, okay, in other words, if the judge were to write in a final judgment that you're going to get the death penalty and to issue him a sentence of death, I think first of all in Idaho, I think the chances of him actually being executed are very low. But because Judge Boyce, I believe, has mishandled this case, okay, I think the chances of Chad ever being executed are basically zero. Okay, I really think effectively, I think there really is no death penalty for Chad Daybell, except obviously the state will maintain the death penalty on the table just as a bargaining chip, because that's always a bargaining chip to get people to do a plea bargain to a lesser sentence. So I think for that reason alone, I think we can look at the death penalty just as a bargaining chip. And I now want to try to explain why I think Judge Boyce mishandled this case, even though it doesn't really make a difference. I mean, in Idaho, there really isn't a true death penalty, but I'm still going to try to explain why I think Judge Boyce mishandled this case. So the first problem I see with Judge Boyce is I think he's relatively young, and I think he has almost no experience or very little experience with death penalty cases. Okay, and probably almost no judge in Idaho has a lot of experience with death penalty, just because Idaho doesn't do a lot of death penalty cases. Okay, so just the lack of experience with death penalty cases and the lack of savvy in handling death penalty cases. Okay, number two, okay, almost never does a death penalty defendant have private counsel. That's almost unheard of, and it almost never happens. So when it does happen, okay, obviously the judge can't interfere too much with the defendant's right to choose counsel if they want private counsel. However, what the judge can do, and this is a trick, the judge can hold a lot of status conferences and always remind the private attorney and just remind him and make him talk about what is the financial position of your defendant, like monitoring his indigent status, right? And even though the judge can't force an attorney to withdraw, he can press on him, the fact that, hey, you already blew through your retainer a long time ago. Like, this guy paid you with a house and whatever little money he had. What is he paying you with now? And he could have been checking on this a long time ago to kind of really focus and say, hey, it's going on record here in this status conference. I think your client is indigent, and I'm concerned about a conflict of interest because you've got to mount a super duper death penalty case and this guy has no funds. And the judge could just sort of pressure the private counsel. Okay, that's not really like forcing him to do anything, but judges can use pressure in their status conferences and basically make the issues come out earlier, so that we don't wait years down the line to get this motion that John Pryor filed just recently. when really he probably should have filed that motion a long time ago, okay? Because I'm pretty sure that he ran out of resources a lot earlier than this. I think he just enjoyed the delay, and he's been using this as a delay tactic. So my main criticism of Judge Boyce is I think he's been too passive in his status conferences, and I think he should have been pressuring John Pryor more and more repeatedly to get him to sort of report to the court or sort of give the court some idea of what was Chad Daybell's indigent status or his financial status. And I think it would also have been fair in repeated status conferences, and I mean frequent status conferences, okay? I think the judge should have been more aggressive, and he should have had more frequent status conferences to sort of pressure, and I think even kind of, to pressure John Pryor, and basically not only pressure him to talk about his client's financial status, but also to keep pressuring him, talk to me about your co-counsel. Who's your co-counsel? Tell me about your mitigation team. What kind of experts do you have? In most litigation that I do, you have to produce expert witness lists very early in the litigation. These guys, if they don't have like a full team of psychological and mitigation experts, I would say, we don't have a case here, guys. I would have been pressuring them on this way early. If these guys don't have like a whole list of experts, a whole list of retained, like a whole team, like a death team. And I would have told John Pryor like 8 months ago, I would have said, you don't have a death team. You don't have a death penalty defense team, because I need to see much more stuff. I need to see more co-counsel. I need to see more psychologists. I need to see some kind of mitigation team. I see nothing, and I would have been pressuring him hard. So I would have basically made John Pryor file this motion like more than a year ago. You see what I mean? I think a judge could have pressured him more with more frequent status conferences. Okay, so this motion really comes too late in the game. And really, in a way, I think this is a game they're playing, okay? Because I think in a way, John Pryor, he filed this motion, I think, to sort of make himself look bad. And I think he almost wanted the court to deny the motion, okay? I don't think he wanted the court to grant the motion. I think he wanted the court to deny the motion and make it look like they were punishing him. But in a sense, what they're really doing is they're rewarding him. Because what's going to happen is that down the road, after Chad gets the death penalty, okay, he's going to file a motion for post-conviction relief, and he's going to file it on grounds of ineffective assistance of counsel. Okay, he's got such a bad lawyer, but his lawyer is so good because he knows that, like in a state like Texas or Florida, a judge would laugh him out of court, right? But because they're in Idaho, where the judges aren't so smart, they're going to let him get away with a crappy representation, okay? And then after he loses and gets the death penalty, he can then say, I had ineffective assistance of counsel, and he'll be right, okay? So the defense is actually volunteering itself to give him ineffective assistance so that later he'll be able to file a genuine motion for post-conviction relief, and he'll probably get it granted on the basis, probably in federal court. They'll probably go to federal court, and a federal court will take off the death penalty, or take off the whole conviction, based on ineffective assistance of counsel. And I can tell just by listening to Judge Boyce today, I can tell that he's just behind the ball. He's just one step behind the action in this case, okay? Because he's saying, and he's right. He says that, a defendant can waive the right to death qualified counsel, right? If you have a privately retained attorney, you can actually waive your right to death qualified counsel, right? But you cannot waive your right, and no judge would let you waive your right to effective assistance of counsel. Okay, so Judge Boyce is just so far behind the reality of this case. Okay, yeah, sure, I agree. If I can hire private counsel, I can waive my right to death qualified counsel. Okay, but nobody can waive the right to effective assistance of counsel. And so I think John Pryor has actually checkmated the judge. Okay, the judge is checkmated. Okay, the judge is checkmated because the public is hungry for a trial, and the judge is going to look like a donkey if he actually lets Pryor withdraw, because then it's going to put the trial off for another year. And you can see the judge. He says, "Oh my God, if I let you withdraw, then this is going to go on for another year." And what he's really thinking as a judge, I've got all these television. All the television networks, all the YouTubers, the whole public is watching me, and I'm going to look like an ass. I'm going to look like an ass if I end up saying, okay, John Pryor, you can withdraw. And now it's going to put off for another year and a half or another 2 years, because they're going to have to get a new death qualified defense team, right? And so the judge is under all this pressure, and now he has no choice. He has to just serve up Chad Daybell to an unqualified defense, and he's going to have ineffective assistance of counsel. So the judge has been checkmated. Okay. And the only way the judge could have avoided this is if the judge earlier was more aggressive. Okay. The judge had to be more aggressive and more proactive with a lot of status conferences to pressure John Pryor and make him feel guilty and make him want to back out earlier. Okay. But John Pryor, I think, has more experience than Judge Boyce. And I think John Pryor has been smoother and more wily and more manipulative and maybe playing the drag it, delay game. And now Judge Boyce is now checkmated because in the public eye, he's going to look like a doofus. He's going to look like a donkey if he actually lets John Pryor get out now, because we're so late in the game, and that'll delay the trial more than a year and a half into the future, and the public will start to lose confidence in the judge. And because this is a high profile case, the judge has to be on top of the case and can't fall behind and let attorneys manipulate. So basically, okay, so the judge can't look bad, right? So he has to actually deny Pryor's motion, but that's exactly what Pryor wants, okay? Because now they're going to have this crappy homemade, amateur defense, okay? And Chad Daybell is not going to get a true top level death quality defense, right? And so in the end, mistakes are going to get made. He's not going to have enough mitigation. He's not going to have enough experts set up. They're not going to be able to put forth a genuine mitigation case at sentencing. And I guarantee you, if he gets the death penalty, there'll be abundant grounds for a post-conviction relief to get the conviction set aside on the grounds of ineffective assistance of counsel. So to summarize this, okay, Judge Boyce, he should have been aware early that it's very unusual to have private counsel in a death case. And he should have said, John Pryor, I got my eye on you, man. Okay. I don't like this. All right. Because he shouldn't have a private counsel. And he may have had enough to pay for maybe 6 months of your time, maybe a year of your time. But I want to know where your death penalty team is. I don't see any mitigation team. I don't see any co-counsel. I don't see any experts. You're going to give me those things, or I'm gonna make this hell for you. And he should have forced John Pryor to file his motion more than a year ago. Okay, so that way he could have granted it and hired a new death team and not look bad in front of the public eye. But I think because there's so much public pressure on Judge Boyce, okay, he's going to look like a donkey if he actually grants the motion now and has to hire a whole new defense team. And so he just got checkmated. I think the judge got checkmated. And I think this case is heading towards a terrible defense where Chad is intentionally, he's not going to get a full-blown death penalty defense. And then later he's going to have all these grounds to get post-conviction relief. And then later on post-conviction relief, the appellate court and the prosecuting appellate attorneys, they can't criticize Chad, and they can't challenge him saying, hey, you waived your right to death qualified counsel. No, because Chad may have waived his right to death qualified counsel, but he never waived his right to effective assistance of counsel. And I guarantee you, he's not going to get effective assistance. And so I think this has been a wonderful strategy by John Pryor. And I think Boyce, unfortunately, he just fell behind, and now he's too late. He's in a corner. He no longer has the luxury in the public spotlight, okay, to delay this case a year and a half into the future or longer. And so he lost. Judge Boyce lost because he's inexperienced and he doesn't know how to dominate these older defense attorneys. And so I think, even with the best prosecutors and the best judge, I don't think it's very likely that in Idaho, I don't think it's likely that anybody would actually get executed. But now we've got a situation where I think if there is a death penalty judgment, like if Chad actually gets the death penalty, he'll never actually get executed, because he'll have all these grounds to have his conviction overturned, okay, set aside in a post-conviction motion, probably in federal court, based on ineffective assistance of counsel. So anyway, that's my opinion. And I think anybody who has any hope that he'll actually get executed, I think, in my opinion, the chances are zero. So anyway, thanks for watching, and appreciate your patience.